let me just assume now, somebody died, a father died, dying without a will, died intestate. A father died an intestate. Now, he died intestate without leaving a will as per who will inherit his property. Then the issue before the court, they then present you as a law student, they are dragging property. Okeke, being the elder of the family, is claiming that Adobe and Nkem should not inherit anything, that he is the chief, he is the grandmother of this family, besides he is the boy of the house. So they should go to their husband's house. Then the matter comes before you as a law student or as a lawyer. Advise the relevant parties. You can advise them now, right? Yes. Citing what? Authorities, right? Yes. So to cite authority, remember, you have to identify the fact that what is before you is a question of what? Customary law, because it is a question of property, right? Yes. And property of a person who died without a will is often governed by what? The custom of their people, right? Yes. So now, you have known that customary law. You can even go further. The other council, it depends on how the lecturer wants to ask you question. The other council, maybe say, Chika is citing customary law, showing before the court and telling the court, my lord, the tradition of my people is that a girl is not entitled. The tradition of the Enugu people is that a girl belongs to the what? To the family of his husband, right? So therefore, he has no stake in the property of his father, right? This is custom, right? Then the other lawyer, the other counsel, you as a law student, is also coming before the court and telling him, my lord, look, oh, in as much as this is the tradition of Enugu people, my lord, permit me to say that the section 42 of the Constitution states that nobody should be discriminated on the basis of what? Which authority have I cited? My lord, give me opportunity again to let you know the decision of the Supreme Court in the case of Okeje and Okeje, where the court stated that any Igbo tradition, be it Hausa, be it Yoruba, that denies women their inheritance is null and void. Which authority have I cited? So with this, I believe, if you talk about authority, you can do better. Yes? Okay. The difference, like I stated by the definition, is that the other one is written down on a document. Statutory authority is written down. Do you understand? There is no judicial authority that is written down anywhere except in what? Cases. Do you understand? So you can only find judicial authority in a matter before people. And judicial authority often support what? Statutory authority. Do you understand? So judicial authority often supports statutory authority. Are you clarified? So with this, you people now understand how we should be arguing and stating our principle on law, right? Yes. So let's just move to our third stage, which, let's talk about definition of law. Now, permit me to say that when we are talking about law, take this thing very important. Right now, I'll no longer be referring you back to authority again. I believe you should know what authority means. There will be no, I keep saying this, there will be nothing like define law. But before I attempt any question in first semester, make sure you define law. Make sure you define law. If you cannot have the wisdom to decipher where you are going to define law as a person, I'm telling you now, before you answer any question, at least for this first semester, make sure you give definition of law. You can do it. Remember, we shall be discussing for maybe possibly next year how to answer problem question in real time. In law, we expected, if you are in political science and the lecturer say define law, nothing stops you from saying law is a body of rules and regulations, blah, blah, blah. But to law, you don't start it that way. You can begin by, it is even pertinent to approach this question for me to underscore the true perspective of meaning of our laws. What is law? According to Thomas Aquinas, law is we are now defining law. And this authority I shall be defining. I would like you people to get it. I'll give you people 5 authorities. 5, for you to define law, you don't end with one definition. You must give at least what? 5 definitions, 4 or 5 definitions. Don't end with only one definition as a law student. Then at the end, there is one, Tochukwu is your name, right? There is one Tochukwu concocted his own definition and it's very sound. That is a good one. If you can devise your own definition, but I told you when you asked me that question online that you must make sure you have stated what the lecturer owns. You're always free, in as much as I say we are nobody in law, you are free to argue, put your own opinion, but it must be when you have what? Stated the. So you don't begin with according to my own understanding. You are nobody for now. So until you become somebody in law, that is when you'll be saying according to. So now, let's talk about definition of law. This word is important. Take all this I'm going to give you. According to Thomas Aquinas, law is an ordinance of reason made for the common good by one who has care of the community and what? Promulgated. Law is an ordinance of the reason made for the common good by one who has care of the community and is being promulgated. We shall still analyze this definition because it's not just a. That's why I want you to, if you can do me a favor, you just, in your exam, you quote the definition, you cram it, you quote it. Doing it that way will give you privilege of what? Analyzing it. Because you are a human being. Your paper, and again, the length of how you write in law is material. It's not just enough for you to use one page and answer a question. They check also the substance of your work, how far you have gone. So you must fill your script. To do that, you are a human. So you must state that definition. So law is an ordinance of reason made for the common good by one who has the care of the community and is being promulgated. Now, this definition of law has, who can just briefly tell me what you understand by this definition? Please. Any person? Have you had this Thomas Aquinas definition? Even those following me, you should show something on it. Summer, I know you have heard it. You can't? Just say something if you can.
So that and made for him who has the care of the community. So that you who believe that okay, going against the law is like back of the sanction, and then you disobey it, you have to face the punishment. Then you have to like obey the law because it has a reason. You know, like contradictory to your own opinion, moral. So you have to like face the law because it's the devil, and then it must be convicted. That's the decision that it must be enforced.
Okay. Thank you so much. You got the part of reason correct. You also got the part of promulgation correct. But then you miss it with John Austin theory. Now, yes.
What you understand is okay, according to the basic,
Yes.
man who succeeds in this is against the definition of everybody.
Yes.
So everyone is
What? You said something about that last statement to me. Yes. Yes. Okay, thank you so much. Thank you. Please, you people should listen. This definition of law is something you must write it in first semester. And I told you must get at least 5 definitions. Now, if I want you to pick this one as it is, so we can then analyze, I want you to quote it in your exam. So Thomas Aquinas defined law as an ordinance of reason for the common good made by one who has care of the community and promulgated. Thomas Aquinas defined law as an ordinance of the reason made for the common good by one who has care of the community and promulgated. You want to say something? Okay. Now, the element here, number one is that this element, after you have quoted it, then as a law student, you begin to analyze it. You can say, now, let's begin this way. You are told to do anything that has to definition of law, or like I told you, people must define law. I can say, before I move to this question, I want you to be answering your law question as if to say you are gisting with a lecturer or you are interacting. That is how you get A or get good mark. If you are writing just to write, you will not make impression. So first impression is very important. You can say, before I even proceed to answer this question, it is pertinent as a law student that I underscore the true meaning of law. I will begin by saying that according to Thomas Arnold, law has no universal definition. But as a law student, the mandate is on me to make an attempt, at least, to provide the true definitions of law. Permit me to start by the one given by my favorite philosopher, Thomas Aquinas, who said that law is an ordinance of reason made for the common good by one who has care of the community and promulgated. There are points that are very clear in this Thomas Aquinas definition, and I proceed to analyze it in the following. Number one, ordinance of reason. I'm asking a question, I will follow you.
Yes.
Ordinance of reason. What does Thomas Aquinas mean when he said that law is an ordinance of reason? Ordinance of reason in the perspective of Thomas Aquinas, you must be saying it in his perspective, not your perspective. Because you are not agreeing with him and you are not disagreeing with him. A law student should stand neutral. That is why we make you a lawyer. You are not siding anybody, you are taking a stand. Because we still have more definition to go. So you can't take stand with Thomas Aquinas so early. So according to the perspective of Thomas Aquinas, one element is clear: ordinance of reason. Ordinance of reason here entails that law, to be a good law, it must be reasonable, it must be justifiable, it must be justiciable. Justifiable and reasonableness means that if the dean of this faculty allow everybody to be showing their tummy, show tummy, so you know, for girls, you people like dressing indecently. So if the dean makes such a law that allow everybody to be dressing as way you like, you know, do everything you like, for morality, for Thomas Aquinas, that law is not reasonable. And because it's not reasonable, it should be disobeyed. Less injust and unless what? Yes. An unjust law is not what? That reminds me, Latinism can serve as what? Authority. You people understand? That is a question for another day. I don't want to go back to authority. I'm done. So Latinism can serve as an authority, just like I stated it. I'm answering my lecturer question, and I want you to be doing the same. So the ordinance of reason entails that any law that is not reasonable, any law that allows same-sex marriage, is not reasonable in the perspective of Thomas Aquinas. That's why in 2013-2014, President Goodluck Ebele Jonathan assented a bill that prohibits what? Same-sex marriage. Because same-sex marriage is what? Not reasonable in Africa, right? If you see all these people, they do like girls, and girls, woman, when they like woman, they look them somehow. For us here, here, Africa, not in the UK or Europe or America, because by virtue of authority in Wade, America, the same-sex marriage is nothing. They can marry anyhow. But here, it's not reasonable, right? So if Tinubu now decide to make such law for Thomas Aquinas, it should be disobeyed. So key elements, where people understand what Thomas Aquinas means. So that's why I want you to, it's not just enough to cram it, you must know the meaning. That meaning is what will give your work flesh. If you have cited it, for me, I used to use red pen, I will quote it. Be careful before you use red pen to know whether the lecturer supports it or Bible supports it. So I can use it. So if you have quoted it, then you begin to analyze it. It will give your work flow. Now, we have an underscore ordinance of reason. You will know what is meant by ordinance of reason. Yes. Ordinance is just a streamlined thing. That means it must be a reasonable, streamlined rules. Are we together? Yes. Then we talk about another element made common good. Number one is ordinance of reason. Number two is common good. Common good means that it must be for the general welfare of man. That means that if Tinubu is making law, just like this recent law they made that ceased to tax people indiscriminately, that thing, are you telling me is for the common good? It is for Tinubu and Mike and his colleague, so they will fly in jet and one man will be moving with the entire convoy of the whole nation. So these are not for the common good. That when we shall come to you will see how all these definitions are not true definition. Are you then saying that that tax law will not work because it's not for common good? Are you saying it will not work? So it will work, even though Thomas Aquinas, but we are underscoring Thomas Aquinas' definition, not because it is working, but because he also has a perspective he has laid about law. So for Thomas Aquinas now, if it's not reasonable, if it is not for the common good, if it is for Mr. Tinubu alone, it is not what? It doesn't qualify as what? Law. This is what you should be analyzing. Then we talk about another thing, promulgated. The general rule is that if you make a law, you should not hide the law for people to disobey the law. I'll give you an example. Under section 22 of the Criminal Code, it says, ignorance of law does not afford one any excuse before any competent court on any matter. That's what we regard in Latin as ignorantia. Ignorantia juris non excusat. Ignorance juris non. Please, at this point, bring my year one. My brain they catch fire for Latin maximum. So you people should be getting used. Latin is only this year one you have time to work with this Latin, and it can give you mark with no Bible. So Thomas Aquinas is underscoring this principle that if you make a law, you must what? Promulgate it. Promulgation could be by making it what? Law. That's why I say now that verify that we say that statutory authority is anything that written down doesn't make it law. it has to be what? Promulgated. Promulgated in the sense of Thomas Aquinas is that it must be made known to people that this is what? Law. It must be promulgated. It must be given effect to work. So this is what Thomas Aquinas said that law is. Are we okay with this definition? Are we good to go with this definition? Theories of law. All this definition has theories of law they are tied to. First of all, what is theories of law? Theories of law could also be known as what? Schools of thought in what? In law. What they simply means is submissions or perspective of law in accordance with a particular people. When you talk about natural law, that is when you talk about this one. This one I define belongs to where? Natural law. Natural law. I want you to understand where Thomas Aquinas is coming from. Natural law are those who believe that the law should be what? Fair, right, and what? Just. Anything that is not fair, anything that is not right is not law. So Thomas Aquinas was defining this law in line with what? Natural law. From next year, we'll talk more about the theories of law. So now let's talk about another thing, Austin definition. People have had Austin definition. So I want to be giving you the exact quote. So you can write it down. Then you can then develop your own idea about based on my explanation. So Thomas Aquinas, Austin said that law is a command from a sovereign authority backed up by threat of a sanction for non-compliance or disobedience. Austin said that law is a command from the sovereign authority backed up by sanction for non-compliance or disobedience. What this one is saying is, let's just treat it as an element. So remember how I started answering that question of definition of law. Still how we are going to, yes? I said, Austin defined law as authority backed by sanction. Let me just give you the exact one. So Austin defined law as a command from sovereign authority backed up by threat of sanction for non-compliance or disobedience. Now let us analyze the element of this definition. Number one is that command. This one is very, very important. It is the one that is obtainable in our society today. This Austin own is the one that is realistic. Other ones are not realistic. So pay attention here. They will ask you questions more on it. So number one is command. Command means that law should not be something that is begging you. Thomas Aquinas own is more of begging. If you go deeply into natural law, you will see their own is more of you should know this is right now. You should know that this is not fair now. They are not clear. But Thomas Austin is trying to say that law should be a command. If it qualifies as a command, it is law. So if law qualifies as a command, it is what? So these are how we are going to just do it. If you leave the definition, then you try to analyze it. So another thing he said about is sovereign. This one is very important. Sovereignty in positive law. First of all, natural law belongs to what? Thomas Aquinas, right? Yes. Austin own flows to which theory of law? Positive law. Positive law. Or you call it legal positivism. So what this one is saying is that law must be a command. It must come from a sovereign authority. Sovereign authority means that, let me give for if somebody comes in, went to your class group on Monday evening and post lecture updates, what do you think will happen? Just post and say sign, that way acting class rep comes in. Everybody will start throwing laughing emoji first. Then after it, you people will be checking on her whether she's okay or something, maybe she ate something else. Then you people will then wonder what is wrong with her. Why are you people treating that way when if confidence or Chris says you people will take it? What is the difference? So Austin is telling us that this one should come from the what? The right authority. Kamsi on as far as this lecture update is concerned is null and void because it's coming from somebody that has no authority or sovereignty. So sovereignty now means that it must proceed from somebody that have that power to do so. If it is not law. Unlike Thomas Aquinas that said that law is an ordinance of reason, his own argument is more of reasonability. But Austin own is more of what? Command from the right word source. Then under the present day, sovereignty belongs to who? Thank you so much. I love this answer. You really understood this one. Sovereignty belongs to the people by virtue of what? First of all, sovereignty belongs to the people, and then through the people, sovereignty then gets to the constitution. Because if you go to the preamble, although that is a lie, but you take it as true, they say, we the people of Nigeria gave us ourselves this constitution, blah, blah, blah. We the people of Nigeria was just some segment of military officer alongside with Rotimi Williams, former, I think he's dead now. They just drafted that constitution and gave us. We didn't come together to give it. But because they have made it, just lied, and we accepted the lie, it becomes our law. So the constitution, sovereignty belongs to us, and through the constitution, we then disseminate power. So what this one means is that, unlike when Austin propounded this theory, sovereignty belongs to the queen, monarchs, and all these emperors and kings and all those. But now, sovereignty then lies with the what? The people. And we, the people, have empowered our leaders to be exercising that power on our behalf. These are the things you are going to say in your paper, so that your work will be flowing. It's not just enough to define it. You analyze it this way, you identify the sovereignty, you talk about section 1.1, which says that the constitution is supreme, and the provision shall be binding on all authorities and persons throughout the Federal Republic of Nigeria. The court, in the case of Attorney General of Benton State, against the AG of the Federation Judicial Authority, supported this principle that the constitution is supreme. In another case of AG of Abia State and 35 others against the AG of Federation, the court also stated that the constitution is the alpha and omega which other law must come to respect. All this one, we are just trying to underscore Austin's perspective. Then these are the authority you can cite to make it your work neat. So you will now understood Austin's perspective, right? Then another thing Austin also talk about is the issue of sanction and obedience. That one is very important. Positive law are saying that law must come with what? Sanction. If you disobey, you must collect. But natural law, who is that person? Aquina, right? Aquina, they are not more of if you disobey, you will collect. They are more of that. First of all, you should not disobey because you have a good will in you. So these are the things. So sanction, obedience are what? Example, when we shall be treating natural law. That is when I will tell you the deficits in this. But what you should know that among the one that is obtainable is what? Positive law. Positive law is the one that is very realistic in our present day Nigeria, in as much as other one are still buying. So how many definitions have we got now? Now let's talk about another definition. You can also take this one now. This one is the one defined by Oliver Wendell Holmes, Justice of the Supreme Court of America, Justice Oliver Wendell Holmes. So Holmes, according to Holmes, he defined laws to mean not Holmes. Holmes spelled as Holles. Holmes. So Holmes defined law not to mean a set of moral or abstract principle, but a practical tool that reflects how judges decide a case. I'll take it again. The essence, I want to just quote it this way so you can help to get the exact quote. And now take this notice as a law student. Whenever you quote something, you know quotes now. If you go to textbook, it's often in the middle. Whenever you quote something, you must make sure you get the exact words of that person. That's even why I have to make sure I read it out so you understand. Because any divergence or any paraphrasing movement shows that you should not be putting quotes. So if you must put quotes, you must get the exact distance correct. So whenever you are writing authority, you want to quote section 1.1 and you can't remember the exact thing, don't close it with quotes. Because if you paraphrase, you shooting yourself. So if you are quoting, you quote it as it is. If you are not quoting, you paraphrase it. Use your own words, explain it. So Holmes say that Holmes define law to mean not a sort of moral or abstract principle, but a practical tools that reflect how judges decide a case. So for this man, you didn't get it. I said Justice Holmes defined law to mean. Justice Holmes defined law to mean not a set of moral or abstract principles. Justice Holmes defined law to mean not a set of moral or abstract principles, but a practical tools that reflect how judges decide a case. He went further. This man stated that law is not that which is made by the legislature. Law is not that which Thomas Aquinas is saying. Remember, when you are talking about John Austin, he's leaning towards what we have today, legislature. But when they saying, this is why we are going to analyze his own, when you say his own. When they is saying that, leave this thing you people are saying, law is what the court decide in case of Eze and state. Do you understand? So in as much as we have seen what the constitution say about, let's use our P2P case again. All of us know that that case is injustice, right? We know that Mahmoud fooled us. But what is the current state of things? Who is the president? So when Holmes is telling you, yes, you have your constitution, you have everything you have, but who is our president now? Decided by who? So Holmes is telling you that whatever you are saying, whatever the court say that is law is law. You can't do anything. Can we do anything about it now? If it's Federal High Court, they will decide. Let me just start from ground. Customary court will decide. No, I'm not agreeing to this. You go to High Court. High Court will decide. No, I refuse, my lord. you go to if it's federal, if you have started with state high court, you then go to court of appeal. Court of appeal by 3-man justice will decide. You say, my lord, no, I won't agree to this. You go to Supreme Court by 7 or 5 justices, depending on the matter at hand. They will decide. If you are not comfortable again, where will you go again? To heaven. We just leave it between heaven and hell. So no who will decide our fate there. So that is the law. That is what justice, when they is saying that, in as much as we know that this is what the law is what the word court say that is. That's why he said, get this thing. The prophecy of what the court will do, in fact, are nothing more pretensions are what I mean by law. I'm quoting Justice Wendell Holmes in supportive of what that definition I gave. He said, the prophecies of what the court will do, in fact, are nothing more pretensions are what I mean by law. So what he's saying is that that thing the court will decide unaware to us is nothing but what they mean by law. So regardless of whatever the statute is saying, regardless of whatever law is saying, whatever the court tell us is the law, is the law. So if you look at this, there is no law. But the court give out law, right? They give out law. So this is trying to allude to the fact of what I'm trying to say about realism theory, that the courts can actually decide what the law is. You understand? But remember, Section 4 empower the legislature. Section 6 is about the judicial, right? So supporting this theory much will lead to what we call usurpation of power. Do you understand? That is when we talk about theory of law. That is when I was telling you this. But in that one, you know you are answering it, trying to bring out the whole side. Do you understand? So that is what this theory is saying. They are realistic. That is what we say realism theory. They are practical in nature. So the law may be, especially in Nigeria, if there is any other theory I agree with, it must be this one. We have seen where something is very looking black, the court will say it's white, and they will get away with it. Including the last election, including the one to come tomorrow. Including, I actually don't agree with it, but I know people will stone me. But I've read that judgment. I don't see much injustice there. There is. So what makes it unjust? Okay, I want to hear everybody. What is not the Tinder? What is not the Tinder? What is not the Can you guys not the Tinder? What is the word? Yes.
So like he wasn't arrested legally.
Legally.
He was extradited.
Yes.
So, like, he
Thank you. So another person, I've got your own perspective, another person that have view of why it's injustice. Any other person? So all those people okay, if I agree that judgment is just, raise up your hand. I pop are not here, raise up your hand now. If you agree, just raise up your hand. Okay, if you don't agree, raise up your hand. Don't. So we have many neutral body here. Okay, look at, please, I want to be realistic. You know, Nnamdi Kanu is my beloved brother. So to meet me to be realistic, I'm the law, so I have to be realistic. Law is not emotion. See, I'm one kind of, if you follow my channel, you see how I talk. I follow Nnamdi Kanu very well. I report it very well. What I always talk about is that first, that matter is not a legal matter. It's something that goes beyond legal. It's something that can be solved politically. Whenever I use that word political in my channel, what I mean is that it's something that can be solved by agreement, not by law. The law, they have exhausted the law. They are just wasting time in court. The law is clear. All of us know the law is clear. But they don't want to follow the path that will lead to the solution. That is my anger. In fact, I want to stop talking about that case because it's vexing me. I've read that judgment. That judgment is the longest judgment I've ever seen in my life. I have to read this thing. I even got time, but I want to complete it. The judgment that is about 144 pages. The highest I have seen as a law student. That is to show you how seriousness that case is. And the judge was trying so that he will make you not to tell him that he's a bad man. The judge is, as far as I'm concerned, the person on trial is not Nnamdi Kanu but the judge. The judge is scapegoat. The judge is afraid. If I go on Nnamdi Kanu now, Tinubu and his people will chance me. If I go to Tinubu now, IPOB and their people will chance me. Where will I stand? The judge was just doing like this. So this was how the judge was doing. He was not standing in any particular place. He was dancing. You will see his dancing, especially in the punishment. Ordinarily, Nnamdi Kanu should be convicted for death if the crime was proven as he claimed. So there is no need of life imprisonment and all those things. That is where I fought it. Now, talking about what you said, extradition. First of all, the rule is that everybody, you can be arrested with warrant or without a warrant. There is no provision that says that you must be given a warrant. It depends on the offense. Now, the offense is being charged goes beyond warrant. You can be arrested with that. A good example of offense, you can be arrested with warrant. Serving your warrant is if you have breached a traffic light, just petty offense, you throw naira away, all those offense, they are not capital. Capital means the one that has with death or life in prison. This one has serious offense. They can't imagine if you kill somebody and police serve you warrant, will you stay here? You just look for where to run away. So they will only serve you warrant where the offense is minor. If it's grievous offense, nobody will serve you warrant. That's one, solve your own problem. Now, issue of extradition. First of all, Nnamdi Kanu was arrested in 2015. He was granted bail ab initio in the beginning. Nnamdi Kanu was granted bail. Do you know what happened? Nnamdi Kanu jumped bail. Jumping bail means japa. He ran away. From there, he went to Israel. After 2015, the matter started in 2015. So he jumped bail. Now, since he jumped bail, first of all, he's already in breach of law. He cannot again be given that opportunity of bail again because they don't trust him. First of all, for the court to grant you bail, you must provide a surety. Somebody that will stand and say that if anything happens, come and carry me. So Nnamdi Kanu have jumped first bail. In that breach, he's guilty of that one aside. You talk about firearms and all those things. In criminal law, most of the time, the law is too technical that ordinary man don't know law. I'm talking about if I pass through criminal law. Terrorism doesn't mean terrorism. If I stay here and say, if anybody don't come out, I'll kill that person, I'll make sure I burn down this building, that is amount to terrorism. Because we're already inciting violence. But I remember. Thank you. In 2015, when I was in I was in just one. In the people know there's secondary school anywhere. That time I was just a young boy, just one. That time I used to listen to Radio Biafra that time in my one toy they bought for me. I will be hearing, I don't even know Nnamdi Kanu as a young boy that I will be hearing, shoot them, burn down, bring them down, Niger police, that's zoo, animals. Body is dead. Burn them, you people are cowards. If you don't take them, they will take your life. All those things. In criminal law, second semester, that's when you'll be treating terrorism. Terrorism goes beyond just carrying a gun. If you incite people to violence, if you encourage people to kill, you are doing what? You are involving in acts of terrorism. That is element. For you to prove offense, you must prove element, step by step. Like the one of Kamsi example I gave. For you to prove murder, you must say that there must be a dead person. Without a dead person, the issue of murder does not arise. For you to prove terrorism, you must lay evidence of what? Threat to violence or violence. It mustn't be actual, meaning real violence. It could be constructive, meaning in anticipation. So do you understand? You want to say something? Yes. Okay. This thing is actually where I have issue with Nigeria. Do you understand? The problem is that we have two laws here: the laws for the cabals and the laws for the pitied or for the innocents. So, if you are in a nation where law works, there is one man known as Sari Dokubo. That man should also be in the bar, behind the bar now, in the prison. But you see how he's parading himself, the God. Is he go to north and see most of them parading themselves, even in government house? Nobody will look at me, all the. So that is the problem. But then, as a law student, they say two wrong doesn't make what? Right. So if you must argue like this, make sure you are dropping your title as a law student. If you are now a law student going before the hostel and talking, if you want to talk that one, make sure you are saying it as a person you are, person with emotion. Do you understand? Because if you are not saying it will be absurd as a law student to say that if you free this person because he commit a crime, free this person. It doesn't make sense in legal speaking. What? Oh no, that one is different now. That is free in that aspect is legal. I'm talking about just saying because they are free in other things. In fact, many people are with AK-47, the Capone are going around with convoy killing. Why other people are being victimized? So, as a law student or as a lawyer, you can't say because they are doing this person this thing, they then throw away our laws. Rather, you encourage them. Whatever goes to Nnamdi Kanu should do what? Goes to other people. That is my own comment. That is my own stand. They should not treat Nnamdi Kanu this one, treat other. But I will not say the after all. Sorry. Okay, that you know what the governor. The problem, I don't know. Our problem is too many. Normally, self-help is not is a crime in the law. Like the law doesn't encourage self-help. Self-help. It means protect carry taking law into your hands. Like everybody now is going with cutlass or AK-47. If you shoot me, I shoot you. That kind of thing. The law doesn't support that. There are plethora many cases that have been decided, and the judge keep criticizing the taking law into your hand. But the problem here is other people are operating in another dimension. Then other people are operating in another dimension. Some people are meant for the law. Then the other people are above the law. So that is where we are getting it wrong. But then let me just say something about this judgment. First of all, Nnamdi Kanu is arguing that he committed a crime and there is no law in Nigeria. There is no law in Nigeria. And the crime he committed was not, there is no, show me the law. He used to say, show me the law, show me. Actually, you don't know. Actually, it is not right. Look at, when he was doing that thing, that law was enforced. The rule of law is, you cannot be, if you are here now and you commit a crime today, tomorrow they cannot make law to convict you for that crime. But if you commit a crime today and the law is enforced that you should not commit that crime, and tomorrow they repeal that law, take down law, that your action will stand. Do you understand? So this is the problem. Nnamdi Kanu, I don't know whether you don't understand or you don't want to understand. When he was doing that thing, that terrorism act was in place. Do you understand? So when they started action, remember the court didn't end his matter, he ran out, he ran away. So when he came back, they were still trying him under that law. Because if now look at why he's dicey. If they refuse to try him under law, they can't convict him again because he has not committed another crime against the present law. And they can't let him go for the one he have done before when they have not finished it. You understand? So he's still waiting. If they say, okay, Nnamdi Kanu, we want to use new law now to try you, that section 36 sub 12 will be against them. Because he say you cannot punish someone when the crime is not written down, right? Yeah. Then, can somebody open section 36 sub 8 in Constitution? So that is the problem. Section 36 sub 8, if I open it, just tell me. So that is the problem the courts are facing now. And Nnamdi Kanu was trying to say there is no law. But when he committed that crime, that law was in place. And had it been the court finished his matter before he traveled out, it could have been easy. But they didn't finish the matter. Then they want to continue where they stopped. Nnamdi Kanu is telling them, there is no law. Show me the law. Omotosho, show me the law. Then can you read it? Section 36 sub 8. Please listen.
No person shall be held to be guilty of a criminal offence on account of any act or omission that did not at the time it took place constitute such an offence, and no penalty shall be imposed on any criminal offence greater than the penalty imposed at the time the offence is.
You people understood what that section is saying. So you cannot be punished if that time you committed that crime, that thing is not an offense. So if they have choose to try Nnamdi Kanu in new terrorism act, there is also terrorism act now, but the problem is another one. So Nnamdi Kanu didn't commit the action when this new one came. Then they cannot leave the first one. And even naturally in criminal law, if they repeal a law, any action that has been in place will continue until its end. Do you understand? So this is the thing. But for an average man outside there, they don't know this. But regardless, that does not say that what they are doing to Kanu is right. But Kanu too now, it's too do. Okay, come to think of it, how will you be? See how he was addressing the judge. We stop at how many definitions? Third, right? Three. Now, please take this Obiter Dictum definition. So, according to, first of all, Professor Obiter Dictum is a serious person in legal field. I didn't talk to people about secondary authority. I didn't say something about secondary authority, but just take it. Secondary authority refers to the opinions of legal writers, authors, and all those things. So this one I'm giving you now is a secondary authority. Now, Obiter Dictum say that law is a body of rules that regulate human conduct. Obiter Dictum say that law is a body of rules that regulate human conduct. It is only when rules involve the idea of obligation. It is only when rules involve the idea of obligation that it becomes law. When they merely represent the notion of good or bad behavior, they are related to what? Morality. So Obiter Dictum say that law is a body of rules that regulate human conduct. It is only when the rules involve the idea of obligation that when they become law. But when they are merely representing notion of good or bad behavior, they are nothing but a rule of morality. Now, what this one is saying is that he's just laying emphasis to the positive side, which means that law could be immoral and still valid, right? Provided it comes with what? Sanction, which is what we're operating now in our country and all the legal system in the world. If you go to criminal law, all the provision there, whether it's immoral or not, is not the question before the court. It is whether it's coming from what? Right authority. So sanction is not, I'll give it under section chapter 2 of the Constitution. You can actually argue this. Chapter 2 of the Constitution provides that the government should make sure that all of us have right to free education. If you go to chapter 2, you can read it whenever you are free. Chapter 2. Sorry, O2. Sorry. So if you go to chapter 2 provides that we have right to education. These are binding law, right? It provides that we have right to good environment. It provides that you have right to good health care. Is any of these things being provided to us? It's not provided. Thank you for that question. You cannot sue because of the provision in section 6, sub 6, paragraph B of the C of the 1999 Constitution. That is, where is that our marker now? This place can even give us this thing. Section 6, sub 6, paragraph C of 1999 Constitution. This thing, only this thing, rendered everything that is in the entire chapter 2 useless. What this thing, because we don't have time, I will not like us to read it, but what this thing is saying is that anything that is contained in chapter 2 of this Constitution shall not be the reason for you to go to court of law. You see how intelligent this is? So when we say that Nigeria is a craftsmanship of wickedness, you should know that this thing didn't start today. It started from those that gave us the foundation of this country. They dealt with us. So you are telling me that Constitution provides right to free health. Then you know that I will go to court. Then you say that anything that is not there, why did you include it in the first place? So by virtue of this now, you cannot go to court and tell people are dying in this road. Ordinarily, if this has not been there, if anybody died in bad road, you can maintain action against Peter Mba. He will account for it. You will see our nation would have been better. But the idea, those who, Professor Mwabeze, I'm not talking about your regular cultural heritage Mwabeze. So Professor Mwabeze, that is the person that pioneered, is a grown man because you hear more of him secondly. He's a very, like, the courts respect the man. So Professor Mwabeze was arguing, he was the person that fashioned, he was part of this Constitution. He was arguing that if they have not included this, what it means that every day the government will be suffering litigation. They will drag Peter Mba here, they will drag Peter Mba here, they will drag Tinubu here. Court will be filled up with what? Cases. Because if anybody die, you go. That is the problem. They are carrying it with their pocket. They are putting it with train their children in Oxford University. Why will be going here without fan? So this thing now is a very dangerous section, and that will tell you that actually, I got his ongoing shot, but let's leave it for God. So this is just to tell you how this Constitution works. And now let's talk about Professor Oba. Now listen to me. I want you to follow this definition because I told you whether they act law or not, you must do what? Define law. So it is certain we have all agreed that we must find a way to define law, right? In all our questions. Now, it depends on how the question was posited to you, determine how many you are going to give. If the question has everything to do with definition of law without expressly stating it, you know they will not give you define law, right? But if you know your reasoning shows that this question has everything to do with understanding of law or legal method, you must give more than 5 authority. But if it is something that is not based on the definition of law, or it's out of necessity because I said you have to, you can actually give briefly. Do you understand? So you then move all the definition after it is summarized with Professor Bago. Now, there's a way you make A or you appease your lecturer. If you start good, then you proceed. At the end, that place is going to give you block mark. You give him prize, you know. Do you understand? You give him, everybody like to be noticed, to be loved. Can say, but I will go with the favorite definition given by my own amiable lecturer. So look at what you do. You check. You bring your red number and do like this. By that time you have gotten him. According to my own amiable lecturer, he has provided me with definition which obviously has made the law clearer to me. But email like this, trust me, even if his heart is stone, he will give you something. So you just give him that exact definition. Oh, by the way, you must cram it. You must cram it. I don't see any other thing in your head. At least me, I don't pass through a lot in this law. So at least now you have time to cram. So you must cram it. If at some point you are confused, like only thing you need to do is just don't quote it if you can't remember it. But make sure you are saying something that has to do with it. Do you understand? But if you must quote, you must give it to him as it is. So now Professor Bago just defined law as a body of rules that govern human conduct and enjoy compliance to its provision, so as to avoid penal sanction in the case of disobedience to its requirement. If you cannot remember any other person own, please what? Remember Obago. I said Obago define law as a body of rules that govern human conduct and enjoy compliance to its provisions so as to avoid penal sanction in the case of disobedience to its requirements. So what Prof did here is that he aligned his definition with which theory? John Austin, right? So if you observe, most of the definition we have been given, you see that most of them align, especially Obin Lade, and they align with what? So note it today, John Austin theory is the one that is more of what? Realistic. Are you getting the point? Now, let's talk about something that is very helpful. Overruling a case. Reversing. You people can be reminding me. Overruling a case, what? Reversing a case. People have not gone through that side. Distinguishing a case. People have not read that side. So when you talk about overruling a case, let's even talk about reversing a case. I want to bring in that like this. Okay, to uphold a case or to affirm a case, you'll be seeing this thing. When you say to affirm a case, I told you people there are hierarchy of courts, right? Starting from the court of, let's say, customary court or magistrate court. From there, you move to what? State high court. We also have federal high court. State high court and federal high court, you people used to hear it, right? Nnamdi Kanu is being tried in which court? Why is it not state high court? You are correct, but that could not be the reason. It's once that is what we call jurisdiction. I will not bother you with that because you know it's secondary, so it's not your headache now. But what it simply means that if something happens, you're not fit to go to any court. I hope you know. Like if you are now, you will know that better subsequently. But as a lawyer now, in equity, everything happens. Not because the court is close to you and means that you're going to file action here. There are many things you check. So if any matter that is between the federal government and an individual, especially the one he's being charged of, remember he's charged of treasonable felony, terrorism most often is against the whole federation. So any matter that is between federal government and individual goes to what? Federal High Court. It is the federal High Court that is just like federal government. Matter between the federal government and the individual often go to federal High Court. Now, if it is land matters, issue that borders on states, like a suit now suing Governor Pitamba and Governor Pitamba suing a suit, or we having a contract issue, I pay you this, you didn't pay, or normal criminal matter within here, it will go to what? State High Courts. That is just what you have to know. For customary court, any issue that has to do with our custom, it will start with what? Customary court. Now, if I was talking about affirming a judgment, if customary court rule something on customs, and you are not as the rule, let me just be giving an example. The rule that you are not entitled to property as a lady, just like we saw in Alco Vasagwe, right? Sorry, not Alco Vasagwe. The example I gave you, Ukeja and Ukeja, right? The rule that you are not entitled to custom, to inherit property. Then you go to customary court. The customary court supports it that actually you have no right as a lady to inherit your father's property. You are aggrieved. Then you go to Enugu State High Court. That is what you are taking the matter from the customary court, right? Yeah. You go to Enugu State High Court. If Enugu State High Court supports that judgment of the customary court, what they have done, if they support it, they have done what? Affirmed it. Are we in the same page? Yeah. I'm trying to clarify what it means to affirm or to uphold a case. So if you are still not satisfied, the next court should be court of appeal. If you get to court of appeal, if they still uphold it, if they still accept it, the judgment of the state, they have affirmed it. Now, if the court of appeal go against what has been decided by the customary court or state high court, like if they don't support it and rule, are you going to follow should I? Like case between, let me be using Kamsi, I've been using Kamsi and Kingsley again. So we started this journey. Customary court of appeal ruled in favor of me, that Kamsi as a lady is not entitled to inherit property. Then I am not satisfied. Kamsi is not satisfied. Kamsi went to state high court. State high court then affirmed my judgment that I'm entitled to inherit the father property simply because I'm a guy and Kamsi is not. They have done what? Affirmed, right? They have affirmed. Now we see. Kamsi is still not satisfied. Kamsi went to court of appeal. Then the court of appeal they decide to support Kamsi. What have they done? No, not overruled. Thank you. They have reversed the decision, or they have set aside the decision. Are we together? So we have gotten affirming and upholding, right? Upholding and affirming is the same thing. Now let's talk about overruling. Then we'll talk about distinguishing. If you talk about, if there is any other term like this, you are confused, remind me, because I'm still can't remember them here. So if you talk about overruling, overruling now means, that's where we have to come back to this thing we did before and judicial precedent. Overruling means most often the court that do overruling is Court of Appeal and Supreme Court, not State High Court and all those small courts. Overruling means that case, let's go back to that P2B and Tinubu example we gave. Say the authority there is that Abuja is not a state, right? And you don't have to win Abuja to become a president, right? If 2027 and the matter get to the Supreme Court and the justices of the Supreme Court decide to say that Abuja is a state, no longer it should not be treated. Remember the other one, they say Abuja is not a state. If they then say that Abuja is a state, what have they done? They have overruled the other judgment, right? Does that thing affect Tinubu and Obi? It doesn't affect them. But it does affect any other people that are going to court, right? Thank you so much. So this is what we mean by overrule. The effect of overruling is that if you are citing, if you are a charge and bail lawyer and you are then citing Obi and Tinubu when the court have overruled it, the court will say you don't know what you are doing. That doesn't buy them because they have overruled it. Do you understand? The other lawyer can simply cite, it's happening in court. When you'll be going to court, you'll be seeing, a lawyer will be busy citing cases. Then the other lawyer will just be bringing evidence to be showing the court that this thing this man is talking has been overruled. So after making all those your effort, they will just tell you this can be overruled. All it takes is just to cite the recent judgment. That's why I say provided it's coming from the word, the highest court, right? So that's what we mean over. Overruling doesn't change the fact that Tinubu is the president, but reversing changes it. Do you understand? Overruling has everything to do with what? The present case, but it is changing the principles of what? Law that have been established. So people understand what it means. Is there any other? Another thing is distinguishing, yes. Distinguishing a case. Remember what we said. If this Eze and Kingsley, Eze and State, they are related. Case Eze against the State and Eze and Kingsley. They have similar facts, assuming they are all the civil matter or criminal matter. They have similar facts, and the Supreme Court have decided in Eze against the State. Another matter now is Eze and Kingsley, but in this case, it is before the Court of Appeal or before. Supreme Court is bigger than Court of Appeal and also bigger than Federal High Court and State High Court. Now, let us assume we are in State High Court or Federal High Court. Since we are now in State High Court and Federal High Court, Kamsi is citing authority of the Eze against the State by the Supreme Court. I don't know another person. Tochiko is also citing another authority in the case of confidence at the state. So against the state. So what the court will now do, I mean the trial court judge, like Motosh, that guy that is selling in Nnamdi Kanu, we are in Federal High Court, right? So they are citing Supreme Court judgments. So the trial court will be like, let me check whether the facts in this Eze against the state is related or applicable to this one. Now, let me check too whether the confidence against the state is also applicable to this one. So that process of checking is what we call distinguishing. Do you understand? So he's distinguishing in the sense that he's trying to check that if the authority, we all know authority now, if what is decided here is different, like, remember I talk about facts. In all these things I've been saying, all of them connect. That's why we have to start from the authority so you people will not get. We talk about facts. Like when I was talking about you, fact about law and proving fact of law and proving facts and law before the court. You people remember when I was saying about death that you have to prove that somebody is dead. Then you have to prove about law that governs it. So I'm saying that if you have proved, for the rule is that for the fact that courts have decided, Supreme Court have decided the matter, doesn't make the trial courts mandatory that you must apply it, even if the case are not the same. So he must first of all note whether they are the same. The same doesn't mean that they must be the same party, they must be the same environment. It means that what is in issue must be related. People understand? So if it's a question of examination malpractice, fine and good. Did the examination happen? How did the examination malpractice happen? Was it in auditorio? If it was in auditorio, what provisions of a law did they to make about it? If it is relatable to another case of University of Nigeria and Nsukka, the court can apply that judgment in University of Nigeria and Nsukka, even though this one is a suit. Are we getting the point? So the act of checking whether the fact is related, I know people are still confused. Distinguishing means that if I must apply the judgment, I'm now a judge, trial court judge, that is high court judge, and now I'm faced with the decision of the Supreme Court. The counsels are urging me, that is the lawyers to the parties are urging me that I must apply this because that is how the judicial precedent work. I'm bound to apply it. I will tell the counsel, no, or wait for me to apply this thing. Permit me to tell you that what happened in this case is not related to what is before me. Are you getting it? So it's not related to what is before me, and I cannot apply this judgment. So distinguishing is an action a judge must take in order to discover whether the authority of the superior court is binding on him. I will repeat, distinguishing a case simply means an action of a trial court judge. Distinguishing a case simply means an action of a trial court judge to ascertain whether the judgment or the decision, to ascertain whether the judgment or the decision of the superior court is binding or is relevant on this present case. Is binding or is relevant on this present case. Just understand it this way. Distinguishing, you are presented case telling me that I must apply it, and then I must check whether those facts, you people know what fact means? I've explained facts, right? I must ascertain whether those facts are related. If they are related, what the Supreme Court says is what I will apply. If they are not related, I will take my own decision. Do you understand? So that is what distinguishing a case means. It's just an act of checking whether I'm bound to apply this superior authority. I'm not bound to apply it. Then you people can actually do it. Please take this part, your characteristics of law. Can you people know what Ogago said about it? So one characteristic of law is what? Organic and dynamic. Now, just take it this way. If you lift it, make sure you get this is how you're going to answer it. I am certain that it will certainly come out. Equalities too, especially also in quiz. You will write it from next year. So you must make sure you lift it, like you list it first. List the whole 6. It should be 6, right? If you list the whole 6, then you will explain them. Don't just list and go. You explain them. Organic and dynamic. By organic and dynamic as a characteristics of law, we are trying to say that law grows with the growth of the people. Law is not static. Law moves with the movement of the people. A good example is the fact that 1999 Constitution, we started from the Clifford Constitution, moving from Clifford, all the government students here. After Clifford, now which one? After Richard, which one? McPherson, which one? After this, which one again? 1960, 1960 Independence Constitution, 1963 Republican. Then after 1963, we have 1979. We have aborted 1987 before we get 1999. So are you seeing, these are the examples you can give your lecturer, telling him the emergence of various laws, underscoring which point? That law is organic and what? Organic means that it is then dynamic means that it's growing. So the second characteristic is what? I have this one. I have given you people authority on this one. This one is simply saying that law is not any law that is made to apply everywhere is not law. The law binding on Nigeria, is it binding on Cameroon? No. It's not law. So any law that is binding, law must be made and the territory it applies must be defined. Yes. Yes.
Please, so if these police officers there, if they mistakenly shoot someone and shot another person, like they are chasing bandits and shot another person, this incited section 33 something protect them.
That one is taken care of under section 24 of the criminal code. Section 24 of the criminal code. So that one, I will just briefly talk about it. That one is saying is that, this is where we are called liars as lawyers. Do you understand? This thing I'm going to say now. Section 24 of the criminal code say that for you to be convicted of a crime, it must prove that you have intention to kill. For many people, if death happened here, if somebody died here, go to that security officer. For them, we have killed somebody. For lawyers, there must be something else. It's not just enough. Even if I have my hand full of blood, they see I'm going to play. I will just say they will have to fall. This thing you say happened in the case of Amayo and the state, just exactly as you described what happened there. The police, we are trying to, all these things they say stop. Now you refuse as the Yahoo boy start driving. Then they carry one gun, shoot one person that is not even part of the vehicle. What they call it? Stay bled. Then catch that person. So what will happen is that they will still charge you. Because why they will charge you is that they don't know what happened. They don't know whether you had the enemy and then you're looking for stray bullet opportunity to stray bullet. So they will charge you. But what the council will argue on your behalf, their case is that for you to prove a crime under section 24 of the criminal code, you must show, first of all, there will be death. Agreed. Another thing is, did you have the intention to kill that person? If you didn't have the intention to kill that person, you will go. this is where we attempt liars who will say we will not go to heaven. Exactly this place. But there is, if you go in 300 level, you understand better. But what this thing is saying is, you may not. Okay, let me give you. There is one case, Tim Bukolia and R. In that case, a wife was nagging. You know when we see a wife is nagging. You know this woman when they keep mouth, just keep disturbing the husband. You know, talking of it. Then the husband just brought something. I don't know whether I plan, just something to just keep the woman to keep your mouth shut. You don't talk too much. Then the thing landed on the baby. This thing was in the dark. The thing landed on the head of the baby. The baby died. So the baby is speaking, no. So the man was tried for murder. So the question before the court was whether the man should be guilty of killing. I love the fact that somebody can clap for yourself. I love this thing you are saying. It truly means that you now understand. Should the man be charged? Should the man be convicted? So this is what we mean by intention. In as much as it can be unfavorable in other aspects. Because the man was aiming at the woman. That is what the court said. When they are jail, in that case, say that it is not undisputed that the man was aiming a blow at the woman and not the baby. Assuming without consenting that the blow has hit the woman, there is possibility the woman will not die.
Yes.
That is it. But because the baby is fragile, the baby died. So will you convict him? So because there is no intention. Thank you. Thank you. The question, you know, let me just tell you now. The court is not for that Christmas. For the court to if you go to court, what the court will decide. The court will decide only on prayer. That is what we say prayer. Pleadings. All the prayer you made before the court is what they will decide. So if you go to court now, you are charged for murder, nobody brought the issue of domestic violence, the court will not talk about it. The issue before them is whether or not you killed. So if you didn't kill, let me go. If I killed, convict me. So issue, the judge will not be trying to go to domestic violence and all those things. This one I said about child. Again, Tim Bukolia. Tim Bukolia, yes. You know, I told you people will be seeing R in 300 level. R is standing for Republic or Queen. You understand better. I don't want to go there, it's deep. You understand better where you progress. But it means R there is just like state we have. You understand? It's an ancient case. R represents states as of then. Which point led us to this thing? Territorial scope, right? Okay, this definitely. So let me just be giving you authority. Any other one again? Okay, for reasonableness, that is when you are going to use the authority of Thomas Aquinas. Do you understand? You can just say that after saying, first of all, how you are going to approach this? Hello? How you are going to approach is that after you have identified that you list reasonableness, then you say something about it. You can bring with authority. You can begin with authority if you like. You can just say this reasonableness align with the assertion of Thomas Aquinas. Then you can define what Thomas Aquinas says and continue. Another one again. Inspirational. That one is just it's still leaning towards natural law. My iPhone, it's still leaning towards what? Natural law. Inspirational means that ordinarily, the obedience to law should not be based on sanction. Do you understand? Law should have the natural tendency to command the obedience without being punished. So in as much as there should not be like, you do this, you do that, something will happen to you before you obey law. So what this one is saying that if you are making a law, make sure that thing should resonate with the people. Okay, will anybody tell me that right to life, that is, apart from being an offense to kill, ordinarily, will you kill? You will not kill. That is inspiration. The inspiration idea is that life, there is sanctity of life. And you will not like to take life, whether there is law or not, except if you are now animal in human flesh. So what again? Okay, that's it. Then you also know this after you know qualities of law, you can do that. Another one I want you to know, finally we'll conclude is this one. Take note of philosophy. You are going to face something. He may tell you people, write short note on philosophy of law. Write short on sociology of law. So these things, you have to take note. Law, order, and morality. take note of this thing. It's going to come by write short note on. There is no problem question there. Just write short note. Writing short note doesn't mean you give me this book. The law, you just write this thing and submit because they say short notes. This thing. Writing short note in this could be used just literally. It doesn't mean you should write short note like that. Say everything you know about it. Do you understand? Are we together? Yes. They can't tell you write short note in law, you go and say it's short note too. Like your secondary school vibe. No. You have to just everything you know about it, say it. Except if you can't. But wherever you stop, make sure it's elaborate. So now, if you are talking about, I'll summarize with this one. You go understand the idea of sociology of law, yes. Philosophy of law, yes. Law, morality, and all that. Yes. So no need of us talking about it. Okay. Any question? Yes. It asks in whether you must cite statutory, legal, maximum, also add case law. First, all this authority can help you. Anyone you remember, you cite. Where you can't remember cases, you cite statute. Where you can't remember statute, you cite what? Latin maxim. Where you cannot remember Latin maxim, you cite secondary authority. That is textbooks. Do you understand? So, if you can remember all, you add it. But just be flowing. You mustn't let anyone you remember here, you cite it. But make sure you must cite something that is called authority. Where Latin maxim apply, you want to talk about less just and unless you can cite it. So, you. Okay, the why, starting with the why lies on the part of sociology of law. Sociology of law is trying to say that law should take note of the social background of the people. Do you understand? Ordinarily, we are not meant to be Nigeria because our way of life is different from northern way of life. Under our tradition, a man can worship his idol with alcohol. Do you understand? You know, if you go to village, they used to worship idol with alcohol. In the north, they don't drink alcohol to serve their god. So you see now that if you say one of the things contained in penal code is that drinking alcohol is a crime. If they have said that drinking alcohol in the south is a crime, they will match the law like this. They will not. That's why they say. That's why all these things collect. This one also connects you to philosophy of law. That is law checking the availability of obedience. You can't just wake up morning and make a law. Before you make law, you must check. Will these people obey this thing? Will obedience supersede disobedience? If disobedience will supersede obedience, that is where philosophy of law will come in. The sociology of law has to do with taking background records of the people. So why the penal code is applicable in the north is because their way of life, they check the Europeans, the British check that our life are different. For them to make it work there, they must have it incorporate. They must put some religion aspect of it, which is adultery, is against Prophet Muhammad, alcohol, Muhammad, and so many other things. If there are some offenses, they will cut your hand. No tradition in Igbo recognize cutting hand. All they do is banishing. But they not. There are some offenses in criminal code. The punishment is cut your hand. So they can't work it in here, otherwise there will be violence. Then another thing is the difference. The difference lies in the provision. If you go to penal code, in 300 level, you will know better. That is when you do criminal law. If you go to criminal code, just like this section I pointed, some deal with adultery, some is not in our own. But they are still similar, like murder, homicide. They are always similar where the offense are related. But where they are not, they are different. So that answer it, right? So with this, we have laid a good foundation in our legal method, right? Yeah. If you go home, if you know everything we have said today, the only way it will sink to your head is to go through them, yeah? Just go to them.